morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with a Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. In today's lecture, we'll provide another installation on the Anti-Federalist Papers series going on number 48. So if you haven't gone back and watched 1 through 47, I would highly encourage you to do so because understanding the Anti-Federalist Papers in addition to the Federalist Papers will provide you a very well-rounded, very advantageous understanding of the U.S. Constitution, and understanding the U.S. Constitution will be absolutely necessary if you intend to combat any sort of lawfare waged against you, your family, or your hard-earned property. So let's go ahead and jump on over to the Anti-Federalist Papers. There are multiple institutions from which you can get a paper and digital copy of the Anti-Federalist Papers. Go ahead and get both formats just in case you can't access one or the other for whatever infinite number of reasons. While you're out there looking, if you haven't done so already, go ahead and get a copy of the Federalist Papers as well, so you can join us in comparing and contrasting the arguments for and against ratifying the U.S. Constitution. Excellent. So number 48 is titled, No Separation of Departments Results in No Responsibility. This one's from Leonidas, not King Leonidas, not Moan Labe. It's from Leonidas, a pseudonym, because there was a very real present threat in the 1780s, late 1780s, that if everybody didn't get on board, they were going to be persecuted. Alexander Hamilton, one of the Federalists, overtly said in one or more of his pennings, the states and the citizens thereof need to comply or they'll die. They were threatening force. So the use of pseudonyms and aliases in the Anti-Federalist Papers was very well warranted. So from Leonidas from London, obviously did not understand Article 2, Section 1 of the proposed new Constitution, but his works were welcomed in the London Times. Oh, so this is a little bit of context, or not context, but conjecture by the author of this compilation of the Anti-Federalist Papers. So the author of this compilation, not the Anti-Federalist Papers, but this compilation of the Anti-Federalist Papers says, but his works were welcomed in the London Times and either the Freeman's Journal or the North American Intelligencer on July 30th, 1788. Article 2, Section 1 regards the powers of the president, and I think it's the qualifications of the president. Let's see if this critique from the author of this compilation is true. See what Leonidas has to say. So Leonidas, not the author of the compilation of this compilation of Anti-Federalist Papers, but Leonidas, the author of this Anti-Federalist paper, says this. In the new Constitution for the future government of the 13 United States of America, the President and Senate have all the executive and 2/3 of the legislative power. Wonder if that's what he thinks is incorrect. This is a material deviation from those principles of the English Constitution for which they fought with us. And in all good governments, it should be a fundamental maxim that to give a proper balance to the political system, the different branches of the legislature should be unconnected, and the legislative and executive powers should be separate. By the new Constitution of America, this union of the executive and legislative bodies operates in the most weighty matters of the state. They jointly make all treaties, they jointly appoint all officers, civil and military, and they jointly try all impeachments, either of their own members or the officers appointed by themselves. In this formidable combination of power, there is no responsibility. And where there is power without responsibility, how can there be liberty? Such a brilliant question. Let's go ahead and highlight that. So simplistic, so simple, but so direct and so brilliant. The President of the United States is elected for 4 years, and each of the 13 states has one vote at his election, which vote is not of the people, but of electors 2 degrees from the people. That's a misunderstanding or misconstruction. The Senate is a body of 6 years duration, and as in the choice of presidents, the largest state has but one vote, so it is in the choice of senators. Now this shows that responsibility is as little to be apprehended from amenability. Now this may have been maybe the original construction of the U.S. Constitution before it was amended during the Philadelphia Convention. But back to him. We'll reread at that sentence, at the start of that sentence. Now this shows that responsibility is as little to be apprehended from amenability to constituents as from the terror of impeachment. For to the members of the Senate it is clear that trial by impeachment is nothing but parade. From such an union in governments, it requires no great depth of political knowledge to prophesy that monarchy or aristocracy must be generated, and perhaps of the most grievous kind. The only check in favor of the democratic principle is the House of Representatives. but its smallness of number and great comparative disparity of power render that house of little effect to promote good or restrain bad government. Another brilliant critique. The power, well, not necessarily a brilliant critique, but a recognition of a historically reoccurring truth of governance and political science. The power given to this ill-constructed Senate is to judge of what may be for the general welfare, and such engagements, when made the acts of Congress, become the supreme laws of the land. So he's talking about Article 6, he's talking about Article 1, Section 8. This is a power coextensive with every possible object of human legislation. Yet there is no restraint, no charter of rights, no residuum of human privileges. Oops, I think we scrolled up. There we go. Not intended to be given up to society. The rights of conscience, the freedom of the press, and trial by jury are at the mercy of this Senate. Trial by jury has been already materially injured. The trial in criminal cases is not by 12 men of the vicinage or of the county, but of the state. And the states are from 50 to 700 miles in extent. In criminal cases, this new system says the trial shall be by jury. On civil cases, it is silent. There it is fair to infer that as in criminal cases, it has been materially impaired, in civil cases, it may be altogether omitted. But it is in truth strongly discountenanced in civil cases, for this new system gives the Supreme Court in matters of appeal jurisdiction both of law and fact. This being the beginning of American freedom, it is very clear the ending will be slavery. Go ahead and highlight that. For it cannot be denied that this Constitution is, in its first principles, highly and dangerously oligarchical. Go ahead and highlight that as well. And it is everywhere agreed that a government administered by a few is, of all governments, the worst. Signed, Leonidas. Excellent. So if you have any questions, I understand where the author of that compilation, of this compilation of the Anti-Federalist Papers, made that point, made that concern about Leonidas's misunderstanding. Maybe that was the original construction during the Philadelphia Convention about Article 2, Section 1, regarding what was it even? That misconstruction. Anyway, it was a fair critique from the author of the compilation to mention that. If you have any questions about what was said in number 48, maybe questions about what was said in the preceding papers, or there's a topic you'd like me to cover in a future lecture, go ahead and post them down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information to combat any sort of lawfare waged against you, your loved ones, or your hard-earned property. So please, if you have any questions at all, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and I'm not sure what the topic for the next lecture is going to be, but I'll do my best to make it as informative and entertaining as this one, if not more so. Regardless of the topic of the next lecture, until I see y'all then, I bid you all farewell.